The truth about estate planning: a single paper can save a family from court. Imagine, a father worked hard his entire life. He built a small business, made a home, bought some land, educated his children, and kept this satisfaction in his mind that after I am gone, everything will be useful for my family. But after he leaves, there is no peace in the house, but questions arise. Who has the key to the cupboard? Whose money is in the bank account? Who has a share in the house? And who will decide to sell the land? The property that the father built, thinking it was his family's security, that same property slowly becomes the biggest test of relationships. The son says, it is our share. The daughter says, I also have a right. The wife thinks, all this should have been in my name. And then one day, family conversation turns into a court notice. The fear starts from here, because a family dispute doesn't only happen in big households. Sometimes a small plot, a bank deposit, a shop, or a wrong nomination creates such a rift in relationships that it doesn't heal for years. The curiosity is, can simple planning really save a family from fighting? Are things like a will, nominee, trust, and asset list only for rich people, or are they necessary for every middle-class family? Estate planning means something very simple. You legally decide who will get your property, money, investments, business, jewelry, and digital assets, how and when after you. This is not planning for death. This is planning for family peace. It is the preparation for that day when you will not be present to speak, but your decisions will be showing the path to your family. In our society, people talk about insurance, loans, taxes, and investments, but they fall silent the moment it comes to a will. Many people think that making a will is a bad omen, as if as soon as a will is made, some bad signal will be sent. But the truth is that a will does not increase fear, it reduces confusion. Another common thought is that my children will never fight. This is the most emotional and riskiest assumption. Children can be good, but circumstances can change. After marriage, new relationships are added, financial pressure comes, property value increases, and then that same family starts thinking in different interests. Sometimes, the fight does not start from greed but from ambiguity. No one even knows what the father's actual wish was. If there is no written document, everyone remembers it according to themselves. One says, Papa told me. The other says, no, he told me. In court, memories do not work, documents do. That is why estate planning is not against emotions, but for the protection of emotions. Now understand the biggest delusion. People say, I have appointed a nominee so the work is done. But a nominee and an owner are not the same thing. A nominee is generally the name of the person for an institution, to whom the facility to receive the asset is given. Ownership can be decided according to succession law or a valid will. Courts have seen a nominee as a trustee or receiver in many contexts, not as the final owner. Suppose a wife is a nominee in a bank FD. This does not mean that the right of other legal heirs is automatically finished. The nomination process helps the bank in releasing the payment, but the question of ownership within the family can be decided by a different law. This is why just appointing a nominee is not sufficient planning. Nomination is necessary, but without a will, many times it remains an incomplete protection. Now understand intestate succession. Intestate means the person died without a valid will. If a Hindu male dies without a will, then according to the Hindu Succession Act, his property goes first to Class 1 heirs. This can include heirs like widow, sons, daughters, and mother, and shares are decided according to the rules. Meaning, if a person thinks that my entire property will automatically go to my wife, then this is not correct in every situation. If the mother is alive, children are there, the daughter is married, or the family structure is complex, then the distribution cannot be as the deceased person had thought in his mind. The biggest point here is that the law does not read the wish of your mind. The law looks at written documents and succession rules. Through estate planning, you change your wish into legal language so that there is no confusion later on. A will, that is, a testament, is the most basic and powerful document of estate planning. In it, you write who will get your property, how much they will get, and on what condition they will get it. A will does not need to be very expensive or complicated. But it must be clear, valid, and properly signed. In a will, the identity of the testator, that is, the person making the will, must be clear. Assets must be clear. Beneficiaries must be clear. And witnesses must be proper. The biggest mistake people make is that they write in the will, my property should be divided equally among the children. It sounds fine, but practical problems can start. If there is one house, one shop, some jewelry and some investments, then what will equal mean? Who will keep the house, who will keep the shop, and who will get the cash adjustment? Clarity is very important in estate planning. Dividing property into percentages seems easy, but in physical assets the exact method should also be written. If the house has to be sold, who will sell it? If one heir wants to keep the house, how will the payment be made to the other? If rent comes in, into which account will the rent go? These small things prevent big disputes later. Appointing an executor in a will is also important. An executor is the person who helps in getting the will implemented after you are gone. If there is no executor, the family will not understand who should handle the documents, who should talk to the banks, and who should start the process of property transfer. An executor should be trustworthy, practical, and neutral. Choosing an executor just based on age or relationship is not always right. Many times, the eldest son is made the executor, but he is the one with whom there is a dispute in the family. In such a case, a neutral person or professional advice can be better. Now understand the angle of minor children. If the children are young, just writing the property in their name is not enough. A minor child cannot legally manage their property. Therefore, guardianship planning is necessary so that the child's care and money management remain clear. If both parents are no longer there, who will take care of the child? Who will take decisions on their education, health, and daily needs? This matter is definitely emotional, but very necessary. While choosing a guardian, look at responsibility, not just love. Whether that person is financially disciplined or not, whether they understand the child's values or not, and whether they will be able to fulfill a long-term commitment or not. Estate planning is not just about after death. It is also planning for a situation when a person is alive, but is not capable of taking decisions. Suppose a person suffers a stroke, goes into a coma-like situation, or due to a serious illness is unable to take banking and property decisions. In such a case, a financial power of attorney or incapacity planning can provide practical help to the family. But such document drafting should be done carefully according to state law, stamp duty, and legal advice. A living will is also a sensitive concept. It is related to medical treatment and end-of-life decisions, and Supreme Court guidelines and legal procedures are important for this in India. This means that estate planning is not just property transfer, but can also be planning for dignity, health decisions, and reducing the family burden. Now let's talk about a trust. Many people think that only billionaires or very big business families create a trust. The truth is that a private family trust can be a very useful tool in some cases, especially when assets are many, beneficiaries are young, there is a family business, or distribution has to be done gradually. Private trusts in India come under the framework of the Indian Trusts Act, 1882, and can be used for purposes like succession planning, asset protection, and incapacity planning. The International Bar Association's India Estate Planning Guide also describes private trusts as a succession and asset protection tool for identified beneficiaries. In a will, property is transferred after death. In a trust, a structure can be created beforehand, and property management rules can be written in the deed. With the trust, you can decide that the child should not get a large sum of money all at once, but should receive money according to education, health, or monthly needs. If a beneficiary is financially immature, has an addiction problem, or lacks the capacity to manage a business, a trust can create discipline. But a trust is not a magic solution. A wrong trustee, unclear deed, tax confusion, or improper transfer can make a trust a cause for dispute as well. Therefore, a trust should be created only when needed, and it should be created with proper legal and tax advice. Now there is another modern problem: digital assets. Earlier, property meant house, land, gold, and bank account. Today, property can include demat accounts, mutual funds, crypto wallets, email, social media accounts, cloud storage, online businesses, YouTube channels, and domain names. If no one knows the password, the recovery email is unavailable, or the private key is lost, then a digital asset can be practically inaccessible. That is why creating a digital asset inventory is necessary in estate planning. But writing passwords directly in a will can be risky, because the document can become public during probate or legal processes. A better way is to plan the asset list, access instructions, and a trusted digital executor in a structured manner with legal advice. For people with YouTube channels or online income, this is even more necessary. Channel monetization, AdSense, brand deals, and content rights can also be valuable assets. If a creator passes away suddenly and the family does not know the login, ownership, and payment process, the income can stop. Therefore, today estate planning is not just about land papers, but also a backup plan for digital life. Now comes the matter of registration. Will registration is generally not mandatory in India, but a registered will can support authenticity in some cases. Also, After the Repealing and Amending Act of 2025, Section 213 of the Indian Succession Act was removed, which reduced old disparities related to probate requirements and mandatory enforcement-related complications. The PIB linked this change to fairness and uniformity in succession matters. This does not mean that a will dispute will never happen. If the family challenges it, or if allegations of mental capacity, undue influence or forgery are made, the court process can still come into play. But a clear will, proper witnesses, proof of medical fitness and an updated asset list can significantly reduce the possibility of disputes. Another mistake in estate planning is creating the document and forgetting about it. Life changes, so the plan should also change. Marriage, divorce, childbirth, death of a nominee, property purchase, business change, tax rule change, or family dispute. All these events can be signals to update the will. If an old will lists a property that has now been sold, or lists a beneficiary with whom the relationship has changed, it can create confusion. Therefore, estate planning is not a one-time formality, it is like a living document that should be reviewed from time to time. Now understand the importance of an asset information sheet. Many families do not even know how many bank accounts the head of the house has, where the FD is, which locker it is, which insurance policy is active, in which demat the shares are, which loan is pending, and where the property papers are kept. All this is often limited to one person. After that person is gone, the family keeps looking for the wealth. Sometimes a policy lapses, sometimes an FD remains unclaimed, sometimes a locker stays locked for years. A simple asset information sheet can save a family from wandering in the dark. This sheet can contain basic information like the name of the asset, the institution, approximate details, the nominee, document location, and the contact person. This sheet should not be kept in an open place. It should be kept secure, but a trusted family member or the executor should have knowledge of it. Now let's talk about family communication. Many parents make a will but tell no one. Sometimes secrecy is necessary, but complete silence is also a risk. At least the executor should know where the will is kept. A family meeting does not mean a drama of dividing property. It means giving clarity that everything will be done in a legal and peaceful manner. If there is a family business, succession planning becomes even more necessary. In a business, not just ownership, but management is also important. Who will have decision-making power, who will handle operations, and how will inactive heirs get benefits, all this should be clear. Otherwise, after the father is gone, the business, customers, staff, banks and family all fall into uncertainty. A family settlement agreement can also be useful in some situations, especially when heirs want to sit together and decide the distribution peacefully. But relying on an informal verbal settlement is risky. Proper documentation, stamp duty and registration requirements can depend on the facts. The tax angle should not be ignored in estate planning. There can be implications for property transfer, trust taxation, capital gains, stamp duty, and income tax. Sometimes, a plan that looks emotionally good can be expensive in terms of tax or legal compliance. Therefore, combined advice from an advocate, and estate planner can be useful, especially in cases involving high-value property, business, or multiple heirs. Now let's go back to the story. If that same father, who worked hard his whole life, had made arrangements for a will, nomination, asset sheet, and executor in time, the family could have ended the conversation at the dining table instead of in court. After he is gone, he would have no voice, but his written decision could have given direction to the family. The real purpose of estate planning is not to give someone more or less. Its purpose is that your wishes are clear, and there is order in the family instead of fights. This planning is not a luxury for the rich, but a duty of a responsible person. If you have a house, a plot, some savings, insurance, or a digital income source, you have a reason to do planning. By doing planning today, you can save your family from tomorrow's confusion. Because wealth does not always bring happiness. Wealth without planning often becomes the biggest test of relationships. Before placing blind trust in a nominee, joint account, verbal promise, and family trust, understand the legal position. Make a will, list your assets, update nominees, think of an executor, and if needed, take expert advice on trust or guardianship planning. Most importantly, do not look at estate planning through the lens of fear. Look at it through the lens of your family's security, peace, and respect. Because after you are gone, your family will need clarity more than property. And when clarity is written down beforehand, the doors of the court remain closed, and the doors of relationships remain open. So ask yourself one question today. If I am not here tomorrow, does my family know what to do with my property? If the answer is no, then estate planning is not a future task, but a need of today. Wealth created with hard work becomes a legacy only when the right planning is attached to it. Otherwise, that same wealth, which was created to take care of the family, can one day become the reason to break the family.
If this video has taught you something new, or if you feel this information should reach more people, don't forget to like and share the video. Your small share can become valuable and useful information for someone else. If you have any questions related to this topic, or if you would like to share your opinion with us, be sure to write in the comment box. We read every question and suggestion from you, because your feedback inspires us to create better content. And if you want to keep receiving such interesting and reliable information about business, the economy, and the world in the future, then don't forget to subscribe to our channel GRT Business and also press the bell icon so that you get notifications of every new video directly. At GRT Business, we always strive to provide you with accurate, balanced, and reliable information. Our news and analysis are prepared based on information obtained from various news agencies, public sources, and public opinion. We make every effort to verify and validate each fact as much as possible, but in case of any possible error or dispute, the responsibility lies with the respective sources. Our only aim is to present you with a correct and trustworthy perspective so that you can understand any topic better.